calling in re DACA cases. Civil Action 17-5211, Civil Action 17-5235, Civil Action 17-5329, and Civil Action 17-5380. Counsel, please approach the podium and state your appearances for the record.
Good morning, Your Honor. Jeffrey Davidson, Covington and Berlin, on behalf of the plaintiff, University of California.
Thank you. Welcome.
Morning, Your Honor. James Zaratka from the Attorney General's Office, representing the states of California, Maine, Maryland, and Minnesota.
Great. Welcome to you, too.
Morning, Your Honor. Nancy Feynman, Cachette, Petrie, and McCarthy for plaintiff, City of San Jose.
Good morning, Your Honor. Jonathan Weissglass from Altshuler-Burzon. I'm counsel for the plaintiffs in the Santa Clara case, which we're seeking to relate to these cases.
Hey, I'm going to relate them. I thought I already had, but maybe the time hasn't run for that. So you're the fifth case, right?
Yes, Your Honor, and I'm really just here to observe today and make sure that we can fit in efficiently.
Thank you. And there's a fourth case that somebody's not here on. Who is the fourth case? Anybody remember? Is it? But your firm is in the fourth case, right? Well, why isn't somebody from your firm up here at the council table? Well, why don't you come up here anyway? And maybe you can be of use at due course. What's your name again? Okay, so now you have appeared. All right, on their side.
Good morning, Your Honor. Brad Rosenberg from the Department of Justice, Civil Division, Federal Programs Branch, on behalf of all defendants.
All right, so we're here on an issue that concerns the administrative record and a more or less emergency motion by most of the, or all of the plaintiffs to augment, supplement the administrative record that was filed by the agency just a few days ago. So as a first matter, I had sent out an order asking the Department of Justice to supply me with materials that are set forth in the October 10 order. And for at least for present purposes, you can do this on an ex-parte, not ex-parte, but on an in-camera basis. But I can't promise you that I won't order it to be produced. I might, in fact, order it to be produced, but until I see it, I can't. But I do need for you to hand that up. Looks like that's it right over there. Okay, thank you.
Your Honor, these are the documents I would ask, and if necessary, move that before the court considers releasing the documents, that it stay that order so that we can have an opportunity to seek appellate relief.
I'll consider that. Time is of the essence in this case, but that's a legitimate request. I will consider that. I can't promise anything anymore, but I will consider it.
Okay, thank you.
Please hand it to the clerk. I have no idea what's in there, so it looks, just for the record, it looks like about, what will you all say, 3 inches, 4 inches worth of materials in a big brown envelope, right?
It is about 3 inches of materials in a sealed brown envelope. We just would take the position that you are under the order of this court to provide those materials. As you know, we've moved that if the court were to release those materials or consider releasing those materials or otherwise make them a part of the public docket, that would effectively be a move that could not be undone by this court, because once those materials are out in the public domain, they could not be retrieved back. We view these materials as being very sensitive, reflecting numerous privileges, and so as reflected in our colloquy a few minutes ago, we do move that if the court does consider releasing these materials, that it provide us with time to seek appellate review in consultation with the Solicitor General's office on an expedited basis.
Well, that's a reasonable request. Without looking at them, there may be reasonable reasons not to do so, but I understand your point. I will try to honor that if I can. Okay, I don't have time to look at these materials now, so I'm going to proceed with the rest of the hearing without knowing what's in this package, because we're here on an expedited basis at the request of the plaintiffs. I'm here to listen to what you have to say and to just to start off by saying what would be of most benefit to the court at this hearing at some point soon would be to hone in on very specific types of documents or materials that you feel ought to be in the administrative record, as opposed to generalized blather, meaning that if you just give me platitudes, I don't know how that translates to anything. If I'm going to give you an order in your favor, I need to say very specific categories of documents ought to be included. And so at some point, we need to zero in on that issue. But you can begin any way you wish. State your name again, please.
Jeffrey Davidson, Covington and Berlin, on behalf of the Regents of the University of California.
Okay, go ahead.
Your Honor, if I might start where this began, which is the contents of that mysterious envelope that is on the bench. We do have serious concerns about whether the government complied with the order about what they were to bring to the hearing. The court's order was that the government was to bring to the hearing, and I quote, hard copies of all emails, internal memoranda, and communications with the Justice Department on the subject of rescinding DACA, unquote. From the government's papers, we derive that what they've chosen to put in that envelope is only documents in the possession of the Secretary of Homeland Security, and that they would not have included, for example, emails with lower down within the Department of Homeland Security, emails between the Department of Homeland Security and the Department of Justice, or other documents that were not physically and personally possessed by the Secretary of Homeland Security.
When I read that part of the brief, I paused over that and wondered if it was in compliance with the way they had it. I have before me my order, but read to me the language from the Justice Department's brief that makes us wonder whether or not they complied. Here comes some. You need to be prepared next time. I have very little time this morning, about an hour, so you need to have this at the ready next time. Okay, your counsel has rescued you. Go ahead, read it, please.
Thank you, Your Honor. It's on page 4, beginning line 2 of the government's opposition.
Right.
In addition, defendants will bring hard copies of those documents identified in the privilege log to the October 16th hearing. And if the court were to go to the government certification about what's included in the privilege log, which I do have at the ready, they say, and this is the 8-line certification, which is at this court's docket number 64. It says, the administrative record attached to this filing as Exhibit 1 is a true, correct, and complete copy of the non-privileged documents that were actually considered by Elaine C. Duke, the Acting Secretary of Homeland Security.
I don't know what that means. This is what I wanted to be in this envelope. Anything in the world that the agency has on the subject of rescinding DACA, whether it was with the Justice Department or not. It couldn't be clearer. All copies of emails, internal memoranda, and communications with the Justice Department on the subject of rescinding DACA. So if there's an email within DHS that says we're going to rescind DACA, or here are the reasons, or here are not the reasons, or here's why we should or should not do it, that email, even from somebody 4 levels down, would have to be included. Same thing with internal memos, because people don't always communicate by email. Sometimes there's a memo. Or communications with the Justice Department. All of those I meant to be included here. Now, that doesn't mean they get put into the administrative record. That just means I get to look at it to see if I think it should be in the administrative record, because it's hard for me to imagine all the possibilities. Now, let me just ask flat out to the government, did you follow what I just said, or is it truncated?
Your Honor, we did not interpret the order in the way that you're expressing it now. What is reflected in that envelope are the documents that were in the privilege log that we provided. There are two reasons why we provided the documents in this form. First, I would direct the court to the numerous declarations that we provided with our opposition brief. We have been working around the clock, and we have collected in the neighborhood of hundreds of thousands, if not millions of emails that we have to sort through, sift, and collect to figure out what would or would not be responsive to the request, as plaintiffs have put it, in terms of the scope of the administrative
There
record.
can't possibly be a million emails on rescinding DACA.
No, it's not. And I apologize, Your Honor. It's not a question of whether there are a million emails, but in order to respond to plaintiff's position as to what needs to be in the administrative record, both DHS and DOJ, even though we do not think that DOJ is responsible for an administrative record because it's not the relevant agency here, have to first identify all relevant custodians who might have any potentially responsive records. Then those documents need to be retrieved in a forensically sound manner and processed. We have this in the declaration, so I don't want to misspeak as to the volume, but it is literally enormous. And so it would have been impossible for us to provide all of those documents, and we believe that that is well supported by the declarations we provided.
All right. If it's one thing to say, I ask you to do the impossible, and it's another thing to say you're not going to do it. Now, what I hear you saying is you will do what I ordered you to do, but you need more time, then I'll be reasonable and give you more time if that's, in my assessment of this is such a recent event that this is a guess, that there are less than 1,000 relevant emails, less than 20 relevant internal memos that would be covered by this, and that you could do computer searches and probably find a pretty good, with 90% assurance that you got all the materials from your email database. Then you'd have to process them to get those 1,000 emails and go through and say, okay, we're going to assert privilege over these, not over those. Nevertheless, all of them have to be produced to me, so that I can do my job of sorting through there to see which ones should or should not have been in the administrative record. So we'll come back to, I think you fell short in complying with my order, but if the reason is that it was physically impossible, then I'm sympathetic. If it was that you just disagree with my authority to do what I'm ordering you to do, then we have a problem. Which is it?
We certainly do not disagree with your authority on that, Your Honor. That is why I came here with the envelope. But we also do think that our interpretation of the order was certainly a reasonable one in light of the fact that we are here today on plaintiff's motion on which this court has not yet ruled. We have provided those documents that we do not think are part of an administrative record because we don't think that privileged documents constitute a part of an administrative record. We recognize that plaintiffs disagree with that position, but we've nonetheless provided those documents that we've identified that were relevant, or at least that were as part of the acting secretary's DACA file, so to speak. And so we have provided the documents that we had prepared in conjunction with the administrative record that we provided to the court. Now, if this court were to order relief of some sort that expands the scope of what would constitute the administrative record, then we would have to potentially search for and identify additional documents. But we are here scratching our heads, as perhaps the court is, wondering what is it that should in fact be in this administrative record? Because this is not a typical case in which you have an agency rulemaking, for example, and there are many comments, there are hundreds of thousands of comments that are submitted by the public, and those comments may or may not filter up to the ultimate decision maker, nor is this a case of an APA formal rulemaking where there might be an adjudicatory proceeding and those types of indirect materials to which plaintiffs have referenced in their motion would actually be indirectly part of the record, even if not directly considered by the decision maker.
Well, right now, it's what the Ninth Circuit standard is, whatever was directly or indirectly considered by the agency at the time that they made this decision. So, and then we may have to scratch our heads after we get to see what the full deck of cards is. We may scratch our heads as to whether or not any of those cards make any difference. But I think you got the cart before the horse. You're trying to say, well, since this is a legal issue, then nothing really matters except what the judges say. Well, that's one way to look at it. But it could. What if, for example, there are memos in there saying what we're about to do is illegal, or this is incorrect. It's an incorrect, and it would just totally undercut your position that the agency made a reasonable decision, and just reversed its legal. The legal interpretation used to be the exact opposite of what you're espousing now. So I don't know what's in there. I think we have to see what's in there first before we can assess what its impact should be on the ultimate decision under the arbitrary and capricious standard. So no, we get to see the evidence first, and then we'll decide. Now, what I want to do is go through some specific categories. I want to get some, you can stay right there, please. We got 2 lecterns. Let's go through some specific categories of things that you think ought to be in the administrative record that you on the plaintiff side can help me identify. I'll just give you a hint for the first one to give you an example of what would be useful to me. In February of this year, as I understand the history, then Secretary of Homeland Security, who was it, Kelly, affirmatively issued an announcement saying that the DACA program would be continued. Now, am I right about that or not? Is that true? Is that true? Okay. So one thing you could be arguing for is that since these are the same agency, the same question, close in time, that reversal of that initial position should be part of the administrative record. That's a cogent concept that I can say. That's the kind of example of a collection of materials that we should have available to us to consider that I can understand. All right. Now, I tend to agree that ought to be in there. Why isn't that in there? Why isn't now returning to the government, why isn't Secretary Kelly's decision and whatever he relied upon, and indirectly or directly, why isn't that also part of this record?
Well, a couple of things, Your Honor. I mean, first, I do want to draw the court's attention to the administrative record because the memo is in the record at page
the decision memo.
The February decision memo to which the court is referring.
Right.
He did not affirmatively take a position on DACA. He simply excluded it from the modification of the agency's update to its guidance. And so I think that it is overstating it to the extent.
That's possibly a good point. Let me see if I can find that. And this very,
It's page 230 of the administrative record, ECF 64-1 at 230.
All right, 230. What I got is only goes up to page 125 or so. Sorry, I don't. Oh, wait, here is the second part. 230. All right, I'm at 230.
Okay, if you look at the top paragraph, that sets forth the extent to which the memo addresses the DACA program.
This is page, you agree, Mr. Davidson, that page 230 is where I should be looking?
Yes, Your Honor. Very beginning of the page, starting with the language, with the exception of the June 15th, 2012 memorandum.
All right, so it says, with the exception of the June 15th, 2012 memorandum entitled Exercising Prosecutorial Discretion with respect to individuals who came to the United States as children, and the November 2014 memorandum entitled Exercising Prosecutorial Discretion with Respect to Individuals who came to the United States as children, and with respect to certain individuals who are parents of U.S. citizens or permanent residents, comma, all existing conflicting directives, memoranda, or field guidance regarding the enforcement of our immigration laws and priorities for removal are hereby immediately rescinded to the extent of the conflict, including but not limited to the November 2014 memorandum entitled Policies for the Apprehension, Detention, and Removal of Undocumented Immigrants and Secure Communities. Okay, so what that is saying is that a lot of things got revoked on February of this year, but the DACA memorandum did not get revoked.
It was carved out, essentially.
It was carved out, okay. So, all right, so your point is it wasn't affirmatively revalidated. It was just left out of the revocation for the time being. That's your spin on it, right?
That's the way that I read that document, Your Honor.
Your spin on it is what, Mr. Davidson?
I don't know if it's been. There was a conscious decision at the time to rescind all guidance about prioritization for removal except for the DACA program. So there was a deliberate and explicit choice to leave the DACA program in place in February.
Well, that's true. That is true. That's the way I read it too. But it also left in place the one about parents. But the one about parents, the Fifth Circuit invalidated, right? All right. So, but that was before. That happened before this, correct?
It did, Your Honor. And if you look at footnote 1 at the bottom of the page, it says the November 20th, 2014 memorandum will be addressed in future guidance.
Yep.
The November 20th is the memorandum that relates to the parents. So it's leaving out DACA. It's
all
not
right, so
saying
maybe what that means is that DACA will survive, but parents will not, in light of the Fifth Circuit decision.
It may be, Your Honor. The only point we're making is that there was a process that occurred at the Department of Homeland Security prior to this memorandum being issued, and there had to be, and I don't hear the government denying that there was, consideration about whether to include the DACA program in this memorandum or not.
Yeah, that's a fair point, isn't it? I mean, here it is, in February of this year, the Secretary of Homeland Security makes a conscious decision to carve out, as you put it, the DACA program, and that's in the face of and in the teeth of the Fifth Circuit decision. And I just got to believe that somewhere within the agency there was memoranda, emails that discuss the advisability of that or the non-advisability of that, and which then in turn bear upon the very subject of the thing that brings us here today, which is the eventual revocation. So, or rescission, I should call it. So why shouldn't that be in the administrative record, being so close in time, so close on subject, same agency?
Well, I guess I would say a couple of things, if I may, Your Honor, on that. First, I think the proper way to review this issue and decide what should be in the administrative record is to look at the decision itself rather than start by looking at documents or potential documents and try to construct something, because that's the opposite of what the APA provides for and what Supreme Court precedent and D.C. Circuit precedent provide for. And so I would direct the court, and then bear with me on this, but I would direct the court to the actual rescission decision itself, which is on page 255 of the administrative record that we've provided.
All right, let's look at that. I'm going to bear with you for a minute, see where that leads us. All right, 255, all right.
Now, while you're looking for that, I think an important piece of context here is that the February 2017 memo was issued many months before the state of Texas and the fellow plaintiffs in that case threatened to bring a preliminary injunction
You know,
against the DACA
I
program.
must say about that, was that even in writing? Was that threat in writing someplace?
Yes, that's in our administrative record as well, Your Honor, because
Tell me
that's
where that, I want to see how, because I have never seen the United States Department of Justice back down so quickly as they have backed down in the face of a threat. To me, all right, show me where that
The let-
earth-shaking threat is.
Yeah, I'm looking for it right now. It's in the administrative record starting on page 238,
All right.
running through page 240.
Okay, this is dated June 29, 2017, addressed to the Attorney General, and it's from, it looks like Ken Paxton, Attorney General of Texas. And we don't have time to read it all, but I see a key paragraph says, for these same reasons that DAPA, D-A-P-A, now that's what was decided by the Fifth Circuit was illegal, and expanded DACA unilateral executive branch conferral of eligibility for lawful presence and work authorization was unlawful. The original June 15, 2012 DACA memorandum is also unlawful. All right, so then, now that's exactly contrary to what the agency itself had said, but okay, that's the position of Ken Paxton. And now we go further down. We respectfully request that the Secretary of Homeland Security phase out the DACA program. Specifically, we request that the Secretary of Homeland Security rescind the June 15, 2012 DACA memorandum and order that the executive branch will not renew or issue any new DACA or expanded DACA permits in the future. So they say what the request is. They say if you do all of that, then the plaintiffs will dismiss their lawsuit. Otherwise, the complaint in that case will be amended to challenge both the DACA program and the remaining expanded DACA permits. All right, so there's the threat. Otherwise, they're going to expand their lawsuit. And then that's the end of the letter, and it's signed by Attorney Generals of Texas, Alabama, Arkansas, Idaho, Governor of Idaho, Attorney General Kansas, Louisiana, Nebraska, South Carolina, Tennessee, West Virginia. So that's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 states, right?
Looks like that, Your Honor, yes.
Okay, so that's the threat?
Yes.
All right, so in the face of that threat, the Justice Department of the United States rolled over and said, you win?
I would disagree with that characterization, Your Honor. I mean, in the face of that threat,
Well,
as well as
wait a minute, just to be fair now, your Justice Department told the prior administration that this was a lawful program, right? That's probably in here too somewhere.
well, it is in there, and it is in fact one of the documents. Plaintiffs have accused the government of not including any unhelpful documents, but we did include the OLC memo. The OLC memo addressed the legality of the DAPA program, but there is a footnote in the OLC memo that acknowledges that OLC did verbally opine on the legality of the DACA program. But of course, that opinion effectively was superseded by the actions of the Southern District of Texas, the Fifth Circuit, and a 4-4 divided Supreme Court that upheld the preliminary injunction against the DAPA program.
The original OLC memo that I remember reading the first time you were here, it actually did say that the DAPA program was probably not legal, right?
I think it depended on there were a couple of particular permutations of that program that they were opining on, and it depended on I'd have to take a closer look at the memo.
I believe it said that the DAPA program was, for different reasons, was illegal, but that the program for the DACA, the children program, was legal. So the Fifth Circuit agreed with the DAPA part of that memo and did not reach the DACA part. So to me, it looks like these attorney generals had every right, if they wanted to litigate the issue of the DACA program, God bless them, that's fine. But I don't understand why the Justice Department just so suddenly decided that its OLC memo was incorrect.
Well, I want to take a step back, and this in effect brings us back to where I originally wanted to take the court, which was page 255 of the administrative record. Right. And to be clear, it's not the Justice Department that is the ultimate decision maker here. It's the Department of Homeland Security. The DACA program was created, or DACA policy, because it's not a program. The DACA policy was created by the Department of Homeland Security. It was administered by the Department of Homeland Security, and it was rescinded by the Department of Homeland Security. So it's ultimately a HHS decision, which is one of the issues that goes to the scope of what the administrative record should be. But if the court, I don't know if the court has page 255 of the AR in front of it.
Yes, I do. Go ahead. You were making a point on that page, and I probably interrupted you, so go ahead.
Oh, and this is an important point, because I think this does help to define what the scope of the administrative record should be, because the record that exists should be that which is consistent with or would support or include documents that might not support the actual decision. And here, if on page 255, under the title Rescission of the June 15th, 2012 DACA Memorandum, the memo says, taking into consideration the Supreme Court's and the Fifth Circuit's ruling in the ongoing litigation and the September 4th, 2017 letter from the Attorney General, it is clear that the June 15th, 2012 DACA program should be terminated. And the rest of the paragraph goes on to say, in the exercise of my authority in establishing national immigration policies and priorities, except for the purposes explicitly identified below, I hereby rescind the June 15th, 2012 memorandum. That's the decision that's being challenged in this lawsuit.
All right, fair enough, but nevertheless, it's the exact opposite of the decision by the very same agency in February, where they decided to carve out the DACA program from any revocation. So maybe in that decision record, there will be memoranda that either supports or draws into question the arbitrary and capriciousness, arguably, of the later action. So why shouldn't that? See, to me, it just sounds like you want to put into the record the things that help you and leave out the things that might hurt you. It could be that putting in the complete record would actually help you. I don't know. But until we see the complete record, I just have to take your word for it that this is the complete record. But there are all these events out there that seem so related, they should be in there.
But I think, Your Honor, I think respectfully that puts the process backwards. The court should look at what the ultimate decision was that was made by the agency and use that to define what the appropriate scope of the record should be, rather than searching for documents. And plaintiffs have never identified what specific documents they think should be in this record. They've only identified general categories. But identify the specific rather than identify specific documents and then try to build a record from the ground up. Because then this court would be usurping the role of the agency, a co-equal branch of government, in trying to define what the basis for the decision is.
Well, see, let's follow your logic through, though. If I were to decide that the agency did have authority, despite the Fifth Circuit decision, to continue the DACA program, then I guess you would just, at that point, roll over and say the judge has decided the legal question. The agency was wrong as a matter of law, so it's not in accordance with law under the APA, and therefore plaintiffs win. Now, would you accept that?
It's not for me to accept, as this court knows, Your Honor.
Well, I think that is one scenario they're looking for on the other side is that exact scenario. So I have a feeling that what you're going to back up to before this is over is, well, Judge, it doesn't matter whether what you think What matters is whether the head of the agency could reasonably, even if incorrect, could reasonably have drawn this conclusion. Okay, once you retreat to that position, all of this stuff that was in the file becomes highly relevant because it could undercut the reasonableness of coming to the conclusion that they didn't have the authority to do it, to do DACA. So I think you're trying to have it both ways here. I think we need a complete record of what led up to this conclusion that DACA should be terminated because of the letter from the Attorney General and the Fifth Circuit's rulings, and then we get to decide whether or not it was a reasonable decision. So, all right, I understand your position. Time is running out here. I'm not making a ruling yet on this, but give me another example of some cogent, concrete category that we can possibly order to be included in the administrative record.
Your Honor, on the rationale leading up to the February decision, I would just point Your Honor to the case law that we cite in our brief, saying that when an agency reverses a decision that they've had before, you have to take into account what it was that justified the original decision.
All right, well, give me the name of that. I missed that in your papers.
Yeah. Let me give you one citation. All of this comes from a D.C. Circuit case called Fox Communications, but let me give you one that I have handy, which is Public Citizen versus Heckler, 653 Fed Sup 1229, and that's from the District Court for the District of Columbia, 1986. But that will point the court to Fox Communications and a number of other cases that say that when the agency reverses course, they have to consider the things that motivated the original decision and provide an explanation for why things have changed.
All right, well, I'll look at that, but let's go to a different category. We've already discussed. Give me a different category of documents that you think should be in the administrative record.
Next category is documents that were considered by subordinates to the Secretary of Homeland Security. The government takes the position that only documents in the literal possession of the acting Secretary of Homeland Security are part of the administrative record. At a high level, that's inconsistent with Thompson and Portland Audubon, which are the core Ninth Circuit cases about the content of the administrative record. Thompson,
that's the indirect or direct.
As indirect or direct, and it says the full administrative record before the agency when it made its decision. So it's not limited to the documents that are in front of one particular decision maker. And it's easy to understand why. Number one, that's not how agency decision-making works. It's not that there's a pile of documents in front of the acting secretary and she makes a decision and it all happens in a day. There's a process. There's a way by which the Department of Homeland Security uses its policy-making apparatus to digest the information and come to a conclusion.
Well, but how far down do you go how many layers down do you go in the bureaucracy to require production of, let's say, emails, just emails between people 4 levels down in the agency over whether DACA should be rescinded? Are you really saying that we got to go that deep?
There's a limiting principle, but the limiting principle is more than zero. You have to go into the policy-making apparatus to figure out what feeds up to the Secretary of Homeland Security. In this case, from the privilege log, we know the people that the Secretary was in communication with as she made her decision.
Well, who are those people?
Well, if you look at the privilege log, it identifies several dozen people.
Several dozen, like 24? 36?
It's in that neighborhood, Your Honor. I haven't counted them.
All right, so she had communications with, say, 24 to 36 agency personnel on this subject. All right. Now, I'll pause there for a second. Let me ask the government. In my experience, a lot of it is done on paperwork. That's true, but there are also verbal communications made to the secretary. I would be surprised if So were there in this case, or tell me if you know one way or the other, did the secretary receive any verbal input on this decision?
I would be surprised if she did not.
So what if that was important to the secretary in deciding how to make a decision, the verbal input?
Again, that's not typically part of an administrative record. And on this issue as well, I think there are a couple of points that are critically important. One is plaintiffs here still have not identified what the limiting principle for how far down the government would need to go to create the administrative record. Is it DHS headquarters only? Is it USCIS and DHS headquarters? Is it the potential impacts within Customs and Border Protection and ICE as well? Plaintiffs, based on what they filed with the court, as well as the letter that they sent to us in advance of our filing of the administrative record, seem to think that the administrative record should include any document that opines on the legality of DACA that's within, initially they said anywhere in the executive branch, but now appear to take the position anywhere within DHS or the Department of Justice. Now again, there can be no administrative record within the Department of Justice because the Department of Justice did not issue a decision in the context of the APA regarding this program. So I think that to the extent that the court is inclined to provide any form of relief, we do need to identify what the limiting principle is so we know what it is that we're required to search for. I'd also remind the court that plaintiffs in this case, as well as in the New York case, have had the opportunity to serve discovery. Now, the government vehemently objects to any discovery taking place in this case and thinks that discovery is inappropriate, but we are where we are, and depositions, in fact, have already begun here, as well as...
Is there a deposition for this acting secretary scheduled?
We've asked for it, and the government has declined to provide.
I think
the
you should
acting
give that,
secretary.
just because what if she says, just as you indicate is probably the case, that she got verbal input? It'd be good to know what the verbal input was that was given to her before she made her decision. That alone would justify the deposition, I think.
So under the Apex Doctrine, Your Honor, we think that any depositions of senior cabinet level officials is wholly inappropriate.
Apex is a loser with me. I'd overrule that all the time. This is too important, even under the Apex Doctrine. And by the way, it's not a doctrine. That's just what people say when they want to uphold it. It's just an idea some judge had somewhere, Apex Doctrine. And it's not, the Supreme Court has never validated that rule. So in any event, it's not going to fly with me. That would be a legitimate question to ask the acting secretary.
Let me address one other point on that, though, Your Honor. It relates to the scope of discovery in this case, as well as plaintiffs' requested relief regarding the administrative record. This is not a situation in which when courts refer to information indirectly considered by the decision maker, typically what they're referring to in a rulemaking context or even a formal rulemaking context is factual information. Each and every one of the cases that plaintiffs have cited involves type of factual information, be it a letter that was before an administrative law judge that ultimately was before a secretary and was the decision maker, or factual reports or studies that are created or developed in the context of a rulemaking process or some other process where it's necessary for the court to be able to evaluate the same factual information that the agency did in reaching its decision in order to determine whether the decision was arbitrary and capricious. That's not what plaintiffs are seeking here. Virtually all of the categories of information that plaintiffs want are going to be covered by one of several different privileges, be it the worked product doctrine because of the pending litigation in the Texas case, the attorney-client privilege because many of these issues involve the seeking or provision of legal advice, the deliberative process privilege because these are internal agency deliberations about how to develop and ultimately rescind a policy, and depending on the circumstances, executive privilege as well. So it's not factual information that plaintiffs want here. What they want to do is go straight to the privileged information that the government possesses. We think that's not properly part of an administrative record any more than a law clerk's bench memo is part of a record that a court develops when issuing its decision and findings of facts and conclusions of law. But it's particularly inappropriate here in light of the fact that these are core decisions that the agencies are making, and the court has spoken on its view on the Apex Doctrine, but that is something I will say that the government feels very strongly about.
Well, I'm going to, if it's up to me, this is in the first instance up to the magistrate judge, Sally Kim, but my own view is I would order that deposition pronto. Let me address the point that you made about privilege. Here, you wrap the entire decision as based on a legal advice. And when you, at least in my experience, when anyone decides that they're going to rely on advice of counsel, they open up that opinion to all of the underlying pros and cons, everything that was communicated by that lawyer to that client, including contrary legal advice, becomes, even though it might have been otherwise privileged, and is now waived. W-A-I-V-E-D, waived. And that, I think that's a serious problem we got in this case. Let me give you an example. What if there were memos to the secretary that said, that were not produced here, or let's say there were, to make it more realistic, there were memos that didn't go to the secretary but went to whoever it was that verbally briefed her.